There are any number of ways in which people can become permanent residents. The most common way is through, is through a family relationship. About 3/4 of the people who get their green cards do so through a close family relationship with a U.S. citizen or, in some cases, another green card holder. Now, the range of relationships is actually quite narrow. So, for instance, I could not sponsor my niece or nephew unless I take my brother or sister in the package. A grandparent cannot sponsor a grandchild without taking the son or daughter in the package as well. So, the range of relationships: parent, spouse, son or daughter, or brother or sister. That's pretty much it. U.S. citizens can sponsor all of those relatives. Permanent residents can only sponsor spouses and unmarried children, whether they're minors or not. So a permanent resident could sponsor a child or a son or daughter who is 22 years old, but if that son or daughter gets married, that knocks the son or daughter out of the box. Okay? So, the other thing to remember is that some of these categories, some of these relationships qualify a person for a green card without a waiting period or without a waiting list. These are what are called immediate relatives, not just because the relationship is much closer, but also because there's no waiting. Someone qualifies immediately. These are parents, minor children, and spouses of U.S. citizens. So who does that leave out? It leaves out brothers and sisters and adult sons and daughters, whether they're married or not. Those categories are numerically capped. And so as a result of that, there's a waiting list for those categories. And those waiting periods can range anywhere from 5 years to, in one really extreme case, 22 years. That's for brothers and sisters from the Philippines. I actually know someone who waited that entire period and immigrated here after waiting 22 years to come from the Philippines. So that's okay. So that's family sponsorship. The other main way, or the second major way in which people come over is through employment sponsorship. There are actually 4 main employment categories for permanent status. These categories tend to be weighted toward people, with very high levels of education and very, very large amounts of work experience. So, even the names indicate this. The first category is aliens of extraordinary ability. So, I think Einstein or Andy Grove or, George Soros would probably qualify under that. I probably couldn't, or my parents probably couldn't. The next category is aliens of, I'm not remembering this, but it's people who are at the tops of their professions, and, or who are, or who have, pretty exceptional credentials. So, and then there's a third category, which is kind of the catch-all for employment visas. This is broken down into skilled workers and unskilled workers. Believe it or not, there are actually permanent visas available for unskilled workers. The catch is, though, that in order for an employer to sponsor someone under these categories, they in turn have to go through a very long, arduous process with the Labor Department to show that they've done a very extensive labor recruitment and search for people in the United States lawfully to fill this particular position. And if they can't prove that, then they can't sponsor this individual. So it's actually fairly difficult for an employer to sponsor someone as either a skilled or particularly an unskilled worker. And then the fourth category, which bears mentioning, is people who have $1 million to throw around who can invest in the United States and develop at least 10 jobs. This predates the economic stimulus package. Okay, so that's employment. Third major category is refugees and asylees. And some, those of you who work with refugee communities are already probably, probably intensely familiar with the refugee resettlement process. These are individuals who have established a well-founded fear of persecution in their home countries. They go through the resettlement process through the UN and the State Department. They are relocated into the United States, and when they relocate, they are granted refugee status. After 1 year, they are eligible for a green card. Now, the flip side of that is people who come to the United States, make the claim of persecution, and try to gain political asylum. Same standard, same need to establish well-founded fear of persecution, only they're doing it here in the United States after somehow having arrived in the United States. So, these would be individuals who, apply through the Immigration Service or the immigration courts. In some cases, they may raise the asylum claim as a defense to deportation. The point is that they're making the claim in the United States. Pass rates for asylum claims is only about 20 to 30%. Some nations historically have gotten favored, with their asylum claims. American foreign policy has historically been bundled up into consideration of asylum claims, but a good number of people are able to win, and then those individuals are able to claim green cards after 1 year as well. Okay. So that's refugees and asylees. There are a number of other kind of oddball provisions in the immigration laws by which someone can gain lawful permanent resident status. There's a provision called cancellation, which enables people who are here out of status for long periods of time, but who have some kind of equity in the United States. They have good moral character. They have a spouse or child who's a U.S. citizen or permanent resident, and they're able to show that the spouse or child would suffer pretty severe hardship if they themselves were to be deported. This is generally raised as a defense in a deportation case, though it is possible to raise these kinds of claims affirmatively, that is, put oneself into deportation and then make the claim that way. It's a high-risk maneuver. Don't do this at home. But I have seen it work. There are also a number of laws that specify particular countries, most notoriously Cuba. There's a bill called, there's a law in the books called the Cuban Adjustment Act, which says that if you flee Cuba, arrive here in the United States, hang out here for a year, you can get a green card, like that. This law is 43 years old. It was passed in 1966. There have also been bills that cover Nicaragua, El Salvador, Guatemala, Haiti, certain Eastern European countries, specifically covering people who filed asylum claims from most of those countries, but as I mentioned, foreign policy got in the way of the consideration of their asylum claims, and so this legislation was enacted about 10 to 12 years ago to enable those people who got messed up by discriminatory practices in the asylum offices to renew their claims and try to get green cards that way.